Moving on to judicial matters, the Supreme Court has dismissed an application by Ihedioha of the People's Democratic Party (PDP) in Imo State, seeking to reissue the certificate of return as rightful governor of Imo State, stating that Governor Uzodimma wasn't qualified to run in the first place. Justice Tijani Abubakar, in a ruling on Tuesday, dismissed the application for lacking in merit, describing it as unnecessary and vexatious, and such awarded the cost of 40 million naira against Michael Zakame for bringing the matter before the court. Those to be paid are the Action People's Party (APP), Uche Nnamdi, Uche Nwosu, and Independent National Electoral Commission (INEC). In the motion considered to be frivolous by the court, Zakame had asked the court for a consequential order to compel INEC to issue a fresh certificate of return to Ihedioha to enable him spend a 4-year tenure as Imo governor. He said that Senator Uzodimma unlawfully spent the 4 years which Ihedioha ought to spend in the motion. Zakame claimed that the All Progressive Congress had no candidate in the 2019 Imo governorship election, hence Uzodimma ought not to have been made governor on the platform of APC. The Apex Court, however, dismissed the motion on the ground that it has no jurisdiction to entertain such a motion. Justice Abubakar held in the ruling that the request was strange, frivolous, baseless, unwarranted, and vexatious. He further held that the motion was a calculated design to make a mockery of the Supreme Court. Some of the councils and parties spoke on the ruling of the Apex Court.
I will do this over and over and over again. It is based on the conviction of my spirit. This year, I will do about 3 matters, when I felt that they were patently pre-election. This is not a pre-election matter. We were not asking, we are not appealing. There's no appeal before the Supreme Court. It is too well known, it's elementary, that the Supreme Court has 60 days from the date of judgment to deliver a judgment. So we were not appealing. We were rather telling the court to give legal imprimatur to its own judgment.
40 million naira to be paid particularly to the parties who filed processes, including INEC. The sum of 10 million naira was awarded in favor of INEC. Yes, and the reason for that is very simple, that the court has over the years determined this matter and has reiterated that if a judgment has been given for whatever reason, it cannot review it. And more so, by virtue of the 4th alteration, particularly section 285, subsection 7, the Supreme Court has 60 days within which to determine an appeal.
And I think it's good for our jurisprudence, so that lawyers don't just come before this court with anything. You must be sure of what you are coming with. You must be certain of the law before you come before the Supreme Court, because this is the highest court of the land. We don't push them into things that shouldn't come before them.